Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today we're talking about lawyers giving opinions. Cases that should have gone to the Supreme Court of Canada, but didn't. In a family custody case, one question that the court had to determine was whether three children, should be relocated to a different town. And the court considered the best interests of the child in determining whether or not the children should move. Of the siblings, two of the three were not found to have any significant impact by moving to another town. But one of the three children, who was 11 years old, retained counsel. The court considered whether it was in her best interest to leave her current school, and the lawyer provided evidence of her personal opinion with respect to how the child would be impacted if she were relocated. It's very unusual for a lawyer's personal opinion about something to be admissible as evidence in court, and so the question arose and ultimately sought leave before the Supreme Court of Canada as to how much a court can actually rely on a lawyer's opinion about how an impact will transpire for a child in a family custody dispute case. This case raises important issues because lawyers obviously get to know their clients, they understand what their clients' interests are, what's in the best interests of their clients, and through their experience also have an understanding of how certain cases tend to play out and how certain people tend to be impacted by decisions in certain cases. So to that extent, lawyers do provide some expertise, particularly in their nuanced areas of law. But when it comes to giving evidence, it's not normal for a lawyer who's representing an individual also to give evidence in court on behalf of that individual. A lawyer shouldn't be a witness in a proceeding where they're also acting as counsel. So this case does raise this important question, and it has significant implications outside the family law process. Sentencing hearings often rely on statements made by counsel with respect to their client's particular risk of reoffending. In those circumstances, judges often put some weight on the lawyer's essentially personal opinion of whether their client continues to pose a risk to the public. But there is limitation on it. In this case, there was less limitation than there is on a sentencing case when dealing with experienced criminal law practitioners. So where is the line? And how much weight can courts give to statements made by counsel that are effectively evidence versus statements made by individuals that are providing their client's version of events to the court? Where is the line? How do we draw the line? And how is weight determined to this type of essentially evidence given by lawyers through submissions? This was an important issue for the Supreme Court of Canada to consider, particularly because of the spillover effect it can have to other areas of law. And it's unfortunate that the Supreme Court didn't take the opportunity to decide this case and to provide some guidance both to instruct lawyers about how to behave in courtrooms when potentially giving evidence, and to provide guidance to judges in how to receive that evidence. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law. Thank you to Brazen Bull Creative for putting together these videos. Please like, subscribe, and share with your friends.